The Commerce Clause was not the only major change to the 1789 Constitution effected in response to the weaknesses of the Articles of Confederation. Recall that the Articles of Confederation also failed to lodge any taxing authority in the national government, crippling the nation's ability to support an army or navy. Article 1, Section 8, Clause 1 of the 1789 Constitution accordingly provides that the Congress shall have the power to lay and collect taxes, duties, imposts, and excises. Although Congress was given the taxing power, the question sometimes arises whether a particular tax is really a pretext to control state policy. One such case is Bailey v. Drexel Furniture Co. from 1922, also called the child labor tax case. Remember that in 1918, the court struck down a federal restriction on the interstate shipment of goods produced by child labor as not authorized by the Commerce Clause. Congress responded by passing a federal excise tax of 10% of annual net profits on employers that use child labor. The court, in an opinion by Justice Taft, struck down this tax as well. Although the taxing power in Article 1, Section 8, Clause 1 seems limited only by the political process, for Justice Taft, the question was whether this provision really was a tax as opposed to a penalty designed to enforce an otherwise unconstitutional legislative goal. In this case, Justice Taft thought the excise tax an obvious pretext for resurrecting the restriction struck down in Hammer v. Dagenhart. As the notes after Bailey v. Drexel Furniture suggest, the court's decisions prior to and after Bailey in cases where a federal tax is challenged as pretextual have been inconsistent. The decisions seem to relate more to fluctuating views of the permissible scope of federal regulation vis-a-vis the states than to any specific principle for interpreting the taxing power. This returns us to the Obamacare case. Recall that the conservative majority held that Obamacare's individual mandate was not a proper exercise of federal regulation under the Commerce Clause or Necessary and Proper Clause. The last arrow in the quiver of Obamacare's defenders was that the individual mandate was a proper exercise of the taxing power. They faced a significant hurdle in the language of the statute itself, which stated that if a taxpayer fails to meet the requirement of subsection A for 1 or more months, then there is hereby imposed on the taxpayer a penalty with respect to such failures in the amount determined under subsection C. Subsection C, titled Amount of Penalty, provided that the penalty would be greater of certain flat dollar amount or a percentage of a portion of the taxpayer's gross income. The argument was also complicated by the argument about whether the Anti-Injunction Act barred the litigation challenging the statute's constitutionality. The Anti-Injunction Act bars any suit for the purpose of restraining the assessment or collection of any tax. The court in the Obamacare case unanimously held that the Anti-Injunction Act did not bar the case from proceeding because the shared responsibility payment was characterized in the statute as a penalty and not as a tax. Obamacare's defenders had argued that the shared responsibility payment was a tax and that the case therefore was barred under the Anti-Injunction Act. Their argument that the shared responsibility payment was a proper exercise of the taxing power was a difficult fallback position. Shockingly, however, Justice Roberts departed from the conservative bloc and flipped over to the liberal side to uphold the shared responsibility payment as a proper exercise of the taxing power. Justice Roberts argued that the shared responsibility payment could be considered a penalty for purpose of the Anti-Injunction Act, but a tax for purpose of the taxing power. According to Justice Roberts, the individual mandate was not a command to buy insurance, but merely makes going without insurance just another thing the government taxes, like buying gasoline or earned income. He noted that taxes that seek to influence conduct are nothing new, and that every tax is in some measure regulatory. You should hear in this an echo of our discussion of externality theory and Pigouvian taxes. A regulatory tax is one way to force parties to internalize externalities. A government penalty is also a way to force parties to internalize externalities. In fact, in economic terms, it makes no difference whether the regulatory cost is called a tax, a penalty, a liability, a license, or something else. The only reason the label tax mattered here, a legally significant reason, is because of the taxing power. Justice Scalia wrote a dissenting opinion on the taxing power issue for the conservative bloc. According to Justice Scalia, the line between taxes and penalties is clear, and the majority improperly judicially rewrote the statute in order to save it. So, after the Obamacare, what is the line between a tax and a penalty under the taxing power? Is the Obamacare case in any way useful as precedent, or is it sui generis because it involved one of the biggest and most controversial regulatory packages in recent history? Why did Justice Roberts flip on the taxing power question?